Hi again. Good afternoon. We are about to restart the conference with our afternoon program. And the first session will be on the use of AI in government and the public sector. And I will have the pleasure to be leading this conversation with us this afternoon. For this conversation, I will be joined on the stage by Jen Razzo, who is an assistant professor of law at McGill University in Montreal, as well as Catherine Charquet, who is the Seagull Family Professor of Regulatory Law and Policy at NYU, and Marcelo Thompson, who is an assistant professor of law at the University of Hong Kong. I would invite you to give a round of applause to our speakers, and we'll start the conversation. Perfect. Jen, Catherine, Marcelo, thank you so much for joining us this afternoon to talk about this very hot topic around the world, especially but also in Canada, in the US, and in Hong Kong, and I'm sure with your neighbor of China, so much happened, I would say, in the past month. So maybe to kick off this conversation, I would invite each of you to maybe give us like a 3 to 5 minutes kind of short statement, a kind of a provocation on the use of AI in the public sector, and maybe we could go in order and start at home with Jen, and then go to Catherine and Marcelo.
Thanks, Florian, for your kind introduction, and to everyone for still being here after lunch, after a long day and a half, or even 2 days if you were here on Wednesday evening. So first off, what I like to do when we talk about the government use of AI or technology is to highlight that this isn't a new thing. So governments have used technologies, and here I'm talking about administration in government has used technology for quite a long time, and really has been an innovator in the use and development of different tools. So we can think of the different types of tools that have been used in social assistance programs, disability, border control, census taking, and so on and so forth. For example, the first kind of predecessor to the digital computer was a machine devised for the US Census, first used in the 1890 census, that used punch card technology to basically allow for kind of the processing and synthesizing and gleaning of information from census data. And there was no internal memory, but all of the other components of a computer, digital computer, were there with this machine. And this allowed for census departments to categorize people into different classes, to look at one class of people, like farmers, for example, and then consider the data that had been collected on farmers using other different types of categorization techniques. And of course, one of the developers of that tool, Herbert Hollerith, was the individual who then went on to found the corporation that became IBM. So this is just to give a sense of kind of the history of the thing that we're talking about. And for anyone who did any kind of Bible studies when you were a kid, you'll recall that the census taking is also something that dates back thousands of years. So if you can think about, those census taking technologies have existed for a long time, maybe not in the 1890s form, but government use of technology has been around as long as government. And of course, governments use these tools with different ends in mind. And of course, these tools also have many unintended effects. And that's really the thing that I like to focus on, because those are just as important, if not more important, than the intended effects. The second key point is that technology beyond AI matters. I know AI is out there, everyone's talking about it. It's the popular kid in the classroom today. But there's a lot of other tools that interact with AI, some of which we've been talking about over the course of the past few days, that we can't forget about. AI, in other words, doesn't stand alone. We need to understand how it operates within a particular context. For example, how does it function with different types of hardware? How does it operate with different types of software? How does it operate with other tools that are not digital at all, but still equally important, like a decision tree that a civil servant might have on their desk or posted on the wall of their office that they use when they're on the phone with somebody who's called in because they're upset about how they've been treated by the CRA's kind of automated auditing tool, right? Those things matter too. And so when we're trying to understand how tech in government works, we need to look more holistically at what technology is being used and how technologies are functioning together with civil servants. And finally, I would say that tech won't save government. So a lot of the time, salespeople approach different folks in government agencies with a hot new tool that's going to solve all their problems, whether the problem's inefficiency or perhaps bias. And of course, government officials are keen to solve those problems. However, some of the problems like inefficiency or slow processing of files in government are things that have existed for a long time, and in some cases have been exacerbated by technology. So to introduce a new tool to solve a problem that other tools have already been creating or making worse doesn't necessarily get you very far and sometimes makes things worse themselves. So I would urge people who are either studying technology in government or perhaps working in government themselves to really be a bit critical, as we are urging you to be critical about what ChatGPT is producing as poetry. Be critical about promises that will, save government with technology, because very often we need to dig into the tool itself. How does it function? How is it going to relate with other government systems? What kinds of new challenges does it create? And there needs to really be a better assessment of kind of the tool and its effects within different government contexts before it's brought on board. So I'll leave it there, and I think I've given us kind of a good setting of Canadian, but also I think kind of universal challenges and observations.
Oh yeah, I already have like so many follow-ups. I will wait a bit for this, and I will hand it over to Catherine also to share her thoughts.
Great, wonderful. It's really an honor and a privilege to be here. I unfortunately wasn't able to be here yesterday, so I've been trying to mine data in the room to find out about all the things that I missed that actually do directly relate to some of my own work. So I do regret that. I thought it might be worthwhile very quickly to just say how I kind of got to having this pretty obsessive interest over the last, 5 years or so in AI in government, because it's a little bit improbable. I'm a law professor at NYU. I teach tort law, I teach products liability, and I also teach administrative law and regulation. And for about 15 years, I taught this seminar that was basically about regulating public health and safety under the rubric of we were going to look at both liability and regulation. And we did everything from the environment to banking to drug regulation, all sorts of problems. So I liked looking at it simultaneously from what we can do from public regulation as well as tort liability. And over the years, one section of this seminar became about AI. And now you can see the story is that became a larger and larger section, because I became very intrigued by how our governmental regulatory agencies, particularly the FDA, NHTSA, which is the Food and Drug Administration, the National Highway Traffic Safety Administration, regulate pharmaceutical drugs and medical devices, cars, et cetera, were actually using these technologies themselves. So I became really intrigued with the idea of, there was a lot of attention about sort of how should we regulate new technology in the world, but less attention, at least in the US, about how are governmental agencies using these technologies themselves. And it became clear to me that a good place to start looking would be the regulatory agencies like the FDA that actually were regulating medical devices that incorporated AI technologies. Like, one would think that it might matter about things like building internal capacity within the federal government, having embedded expertise, whether they're developing these tools in-house or procuring them, all these really interesting issues. And from the administrative law side of me, there was a lot of talk about, in the US at least, about using really high-level constitutional law principles to regulate AI, and that's all well and good. I'm not here to say that my way is better than any other way, but one might think that that's kind of like regulation in the clouds, and administrative law is regulation in the streets. Namely, this stuff, when HHS or one of our regulatory agencies uses one of these tools in a rulemaking, and they actually have already, these are subject to things called judicial review, or courts will look at it, and there are requirements, and some of those requirements that these things not be arbitrary and capricious mean that you have to have reasons giving, you have to have explainability, you have to have transparency. So these kind of overarching principles that I became frustrated, there seemed to be overall consensus. Who could be against? Although many, I understand, transparency, I almost wrote a paper once called Against Transparency, just to be provocative, but in terms of, you know, fairness, transparency, openness, who can be against? But looking at actually how within federal regulatory agencies, if they're deploying these technologies, they might have something to add to this conversation. And so long story short, I now teach this same seminar. It's called Artificial Intelligence, Administrative Law versus Tort. So it's kind of broken, it's become the umbrella. And then within, we're still looking at the two sides of it. But very briefly, the two things that I think I want to focus my remarks, and hopefully we can talk some more about, is I got involved in one quite massive project under the auspices of ACUS. So ACUS is the Administrative Conference of the United States. It's an independent agency that's designed to sort of commission reports. It has governmental members, it has academic members, and it commissions sort of reports and studies of things happening in the administrative state. And myself and a team of people from Stanford realized that looking at how our governmental agencies were actually deploying these tools was something that we had been looking around for and couldn't find. So we did a kind of massive undertaking. If you're interested, you could go to acus.gov, and in like the query box, you could just put in AI, and you'll find this report and others. We actually convened a seminar. In some sense, this conference is almost a microcosm, absent a few elements, but we did a seminar with computer science PhD students, law students, data scientists, and my collaborators from Stanford and myself ran this seminar, and then we used these students as teams to go in and do kind of deep dives in a few select federal agencies. And we learned a lot through that process. It was actually really, really interesting. There were some striking things that just kind of were against at least what the literature suggested. So for example, we did a canvassing of 142 of the largest federal agencies in the US, and half of them were actively planning or experimenting with AI use cases. So that surprised, you know, you often read that like the private sector, there certainly could be and is a private sector, public sector gap, but there was a lot of activity there. The other thing we learned in typology, everyone thinks that the government just procures everything. Everything is contracted out to companies and they have no idea what are in these tools they're using. More than 50% of the AI use cases that we canvassed involved internally developed tools, and quite sophisticated ones. So we're, the other thing is people look at agencies, you know, and they're very important ones, standards-based agencies like the National Institute of Standards and Technology, and look outward, but they rarely look inwards. Like our Department of Health and Human Services has an entire internal AI strategy team. They have an AI playbook they've designed, taking some of these principles and kind of putting them in operational terms for what kind of work they're doing. So it was just fascinating to uncover all of that and then begin to think how some of the typical problems that we encounter about accountability, about transparency, and the like would play into that. The second, very briefly, report that I've now just completed is one, so that report's called Government by Algorithm, How Federal Administrative Agencies Are Using Artificial Intelligence. The second, and it stemmed from the first. The first one, when we did our deep dive into actual deployed usages, they were primarily in enforcement, like SEC enforcement actions, or adjudication, like the Social Security Administration was piloting some of these. My own real interest is in rulemaking and policymaking in the administrative state, and we uncovered very little in that space, although a little bit. So my second project is actually a piece of that. It's called something like Use of Algorithmic Tools in Retrospective Review. So it actually has some case studies where it was looking at tools and some pilots in the Department of Defense as well as the General Services Administration, and also one in the Department of Transportation. And it was basically looking at the deployment of these tools and how they could potentially be used in policymaking. So retrospective review is a look back of existing regulations that are out there, and you can use these technologies to find conflicting regulations, outmoded regulations, and the like. But the impetus, at least for me, of doing it is to start thinking about where I'll end, which is what I'll call next generation AI in government. So I would say that our first generation, which is very robust, has a lot of kind of siloed pilots within individual agencies. And to my mind, the next generation that we need to start thinking about is its use and deployment in kind of policy-making relevant types that would actually cut across agencies. And the really interesting to me as an academic is I think it has implications about the transformation that needs to happen within agencies. So to be very, very concrete, let's take the FDA. Our FDA is the most stringent ex-ante regulator in the world. We don't regulate most products that way. We send them out into the world and then we let tort liability and products liability suits regulate products. That's a bit of an overstatement, but I think the FDA, as it starts to regulate products that involve, learning mechanism within them, has to shift their model into the post-market regulatory review sphere, where it operates at the moment, but not in a very robust way, and has to sort of think about the idea of how we regulate products very, very differently when we have things that are going to change dramatically over time. But now this is the final. The final point I say is I don't think we start from square one. We have a very robust model. When people say things to me like we've never before tried to regulate, this dovetails, Jen, with what you were saying, we've never before tried to regulate something that goes out and learns. I think to myself, have you ever looked at drug regulation, right? We have very sophisticated clinical trials, but we have very limited information. Then we send those products out into the world and we learn. And we have to think about regulatory mechanisms to get that new risk information back to either regulators or into the hands of private people who will come forward and sue. So I look forward to our further discussion.
Thank you so much. And so you, Marcelo, what have you been looking at regarding like AI within government?
So my general interest in approaching issues concerning technology has been the governance of technological platforms. So I tend to approach the topic of AI in government more from recent developments in my work. I've been working on China's social credit system for a while, and I'm right now involved in a project on standard setting in a Hong Kong context. It's a very specific project in a way, but in a way it's also large. And it's a conceptual issue that has very practical implications, which is in our basic law in Hong Kong, there is a provision that says the following: that the government of the Hong Kong Special Administrative Region shall, on its own, decide on the scientific and technological standards and specifications applicable in Hong Kong. So it's very different from the US, where standardization is a legislative power, right, which is delegated to the executive, but it remains a legislative power in Hong Kong. And this is not a new thing. It's been in our basic law since it came into being. It's a power that is ascribed to the government. So what does that mean, right? And in what realms do we have a standard? So I've been looking into that. But of course, I'm interested in how things come together. I'm interested in the relationships between Hong Kong and China. And I'm very interested in what technology means for these relationships. Because to me, the future of one country, two systems as a principle that guides the relationships between Hong Kong and the mainland is a principle that rests increasingly on a very complex technological equation of how we are going to tackle technological issues that connect us, that connect Hong Kong to China, and that connect Hong Kong to the globe. And AI plays a very strong role in that, in how we are going to deal with that, because AI introduces something that is a very concrete challenge. Catherine was noting how we, in the context of drugs, we dealt with something that is already a learning process. But now, to me, the difference is that this learning process is embedded in this thing that challenges our notions of negative and positive freedoms, the balance between expectations that we have of the state actually doing anything and the state refraining from doing something, and the fact that everything is now embedded. We have this universe, which is a normative and informational universe around us, where we need to make decisions from a justice perspective of how to sometimes rectify things, modify things. And the social credit system is, to me, a discussion that speaks to all of this, because it's essentially a discussion on how to articulate our attributes in the information environment and what role should the state play in this regard. We can have a less interventive approach where we leave the market to define the governance of our attributes, how we are represented in the information environment, or we could understand that the state plays a role in remedying injustices in this representation. So there is a role. Is there a role for the state to step in and to modify this balance that is instantiated in this infrastructure? Large language models speak to that. AI speaks to that. This thing that evolves and that decides and that represents us in a certain way with a certain path dependency that has concrete implications for our ways of thinking and acting and being, right, in the world. So I come from AI from the perspective of my interest in the social credit system and recent questions concerning standard setting, but I think it's all intertwined. And the paradox is that we encounter much less of AI in the social credit system than we would expect, right? Because we have this dystopian view that the government is there measuring us in each of our attributes, right? And that is all done by AI, right? And long story short is that this is just not happening, right? It's very different and much more concrete, much more circumscribed than what we imagine. But I'll leave the specifics to the questions later on to discuss about, right, how Hong Kong and how China are approaching different issues concerning AI.
Perfect. Thank you so much. And so as you, like the three of you mentioned, and like Catherine, you're like insisting on this, that the use of AI in government is not new. It has been around for a very long time, sometimes like in the dark, without like any oversight. Kind of the usual question, like who is regulating the regulators? Because the regulators, kind of like having an oversight over the private sector, we're using themselves, AI system, etc. So maybe I would like to do also like a roundtable, like what are like maybe the policy tool in place, if any, to kind of like govern and regulate the use of AI in the public sector in your different jurisdiction. And maybe I will start with you, Catherine, because you started to like mention the constitutional law aspect, but I'm guessing / hoping there is a bit more.
Yes, you're talking specific structures that would regulate federal agencies' use of AI. So it's a great question, and I could come at it a couple of different ways. There is in some of I'll give one example from the SEC, which had a fairly sophisticated internally developed AI tool for targeting suspicious trading activity. And in deployment of this tool, they found that the frontline enforcers certainly were not prone to what we sometimes read about like automation bias, right? Like they'll just do whatever the tool tells them. They were quite critical of what the tool might be suggesting for where they look, et cetera. And our first project sort of talked about how in some ways it looked like a new form of kind of internal due process, right? Where you have within an agency, you have a lot of talk about embeddedness, you have a lot of embedded expertise within our administrative agencies. And in fact, we have hitherto kind of given enormous amounts of discretion to our federal agencies because of their utilization of expertise. So this idea that it could be just sort of simply displaced kind of gets at kind of existential questions for some people within agencies who think, well, no, that's not, we have all these review doctrines, for example, that you can't review enforcement by federal agencies, and that's based on their use of this kind of discretion. But if you have kind of a tool that could be tracked and you know what goes into it, then I think we would have a new kind of review mechanism that would get. So the first is just to say that this kind of idea of the internal due process, or the actual experts within the agency that actually might be testing sort of how much they want to defer to these tools, et cetera. But I've never been a huge fan of we'll just rely on kind of self-regulation, but it's an interesting in practice form today going on within federal regulatory agencies. The second, the one I've spent a lot more time thinking about, is judicial review. So our judicial review, at least in the rulemaking context of federal agencies, I think is quite powerful. So even before we think about AI, when we think about, major regulations in the United States that are going to be subject to being looked over by what we call OIRA, the Office of Information and Regulatory Affairs, which is today headed by Ricky Rivez, who was a former dean at the NYU Law School. But they basically subject all major regulations to a kind of cost-benefit analysis. And that's a really strong mechanism internally, again, because they're part of the executive branch. But even after that, once they go out in the world, they get challenged. And our environmental regulations are challenged quite a bit. FDA regulations are challenged. And so the idea that impending judicial review down the road affects how much care, how much effort, how much empirical review goes in at the agency level is real. So that's a really strong constraint. And then we get to what most people focus on, which is we have very little. We have a whole lot today of executive orders, and ACUS even has principles. So the organization I told you about before that commissioned these studies, they have recommendations and they have principles about how the Office of Management and Budget, which is the house in which OIRA sits, should have sort of more guidance about use of AI, et cetera. But right now, that's kind of in the, exploratory, phases. I wouldn't say that that's what's governing the uses internally at the moment.
Yeah, and maybe I will use this as a segue to go to you, Jen, because here in Canada there's been a lot of work, and you wrote a lot also on the issues with the administrative doctrine and some of the challenges of using automated decision making in government. And a few years ago, the Treasury Board adopted the ADM directive, and there were many versions and stuff. So maybe if you could try to unpack quickly what has been happening in Canada and where we're at.
Yeah, so I think in Canada it's useful to always note at the outset that while we have the directive applies federally, right? And it's a policy tool. From my understanding, there's AI being used that has not been submitted to the directive process. So yeah, so that's a challenge. I can get it into the directive a little bit in a second. But a lot of AI, or kind of precursors to where we might expect AI to be developed, kind of stepping stone tools that might lead to the introduction of AI, happens municipally or provincially. And those uses of AI would be governed by either provincial laws and policies, or perhaps even bylaws that might be rolled out in that context. So before I get to the federal level, it's important to recall, of course, that there's a lot of places like policing, social assistance, for example, disability supports, and of course the fraud detection that might happen in those programs. These are all well-known kind of zones where AI is developed and introduced, whether it's by outsiders coming in or by innovation offices that decide that they want to craft their own tools. And in Canada, there's a mix of both of those things happening as well. But we have seen, entrepreneurial software developers coming into government, whether it's through hey, we've got this new tool, you should really set up a procurement call so that we can, submit our bid, or whether it's through operating in those innovation offices side by side with civil servants. in developing the tools in-house. At that level, like provincial, municipal, there's, in theory, administrative law that could be used to guide the development of tools, thinking about what a fair process might require, thinking about what an open-minded decision maker might look like now that we have, many people and many tools informing a decision. What reasons might require beyond just explainability, but actually justifying certain types of decisions, and so on and so forth, and also what notice might require in terms of, at what point do people know, first of all, that they're in a decision-making process? How do they get access to information about what kind of information or submissions they can make that will be material or relevant to that process? And we can look at kind of common law principles to glean some insights there, but there's no reason why those insights can't be taken on board by the people who are doing this type of development work. The degree to which they're taking those principles on board is another question. I don't think administrative law is at the top of their mind. They're more thinking about human rights, if they're thinking about human rights at all. Most often it's just privacy and perhaps maybe some jurisdictional issues. So there's a real, I think, kind of opportunity for thinking closely about what law applies and how the laws that are already in existence in Canada might inform those AI kind of and other technology kind of development and use processes provincially and municipally. And then at the federal level, of course, we have the directive, which is one tool among many. We also have a federal human rights code, the Federal Human Rights Act, I guess, that applies to government provision of services, as far as I know. And my understanding is that it requires that services must be provided, without discrimination. So presumably, goods and services that are provided by the federal government or federally regulated bodies need to comply with that law. The degree to which the use of technologies to assist in decisions that involve delivery of services or goods are informed by that law, particularly when you have a lot of different actors in the room developing these tools, is an open question. But that's something that I know the Law Commission has been working on, the Law Commission in Ontario, in partnership with the Federal Human Rights Commission, in developing tools that can be used by tech developers and folks working in government to help them assess whether an AI tool complies with human rights values as articulated in the federal kind of human rights landscape. So I just wanted to mention that. And the directive, of course, is interesting. I think there was a lot of hope about the directive when it came out, and I don't want to write it off, but I think one of the real challenges with the directive and its related algorithmic impact assessment is that it seems like relatively optional. Like, it doesn't seem like there's a lot of accountability about who submits the algorithmic impact assessment, who ensures that one's sent in the first place. There's also, I think, perhaps a need for more robust thinking about who gets heard at the algorithmic impact assessment stage in the first place. And thinking through this, I think I draw on literature and regulatory theory and rulemaking, where typically if you had a regulation that's created, there might, especially a regulation that's going to impact a lot of people and important interests like environmental regulation, even telecom regulation, there's going to be some sort of consultative process. And through that process, which is obviously not going to be a perfect process, but you have at least a space where communities that are impacted in different ways have a place to say, hey, this is going to impose significant harm on us. This is why we think you should either take a different approach or scrap it altogether. But through the AIA framework and the directive, there's no place for them, these people, or these groups and communities, to have a say, particularly on the question of what kind of harms might come from a certain type of tool. So it's always insiders who are making that assessment. And the assessments seem to be pretty generous. So for example, I've read the AIA submission for an immigration visa processing tool that identifies this tool that kind of does a pre-screening and allows for some visas to be granted for folks coming from certain countries if the visas look to be like successful visas in the past. And if there's going to be a negative decision, that negative decision, this is a very oversimplified explanation of the tech, by the way, but if there's a negative decision, then it goes to officials, and there may be some more algorithmic involvement at that stage, but there's people making decisions about what a negative decision. And this kind of lay of the land of the tool has been identified as low risk because, you know, the people who are being identified as having a visa granted, you know, that's all fine and dandy. And then the people who might be at risk of having their visa denied, well, they get humans in the end, so it's not that bad. And this is just a pre-decision anyways. It's just about sorting visas into these categories. And I read that and thought, I think that for anyone who's ever been sorted into the category of like, oh, you don't get this thing, and not only that, or you might not get this thing, but then you have to go through this long process, and then other people end up getting sorted into a category where it's just kind of like rubber stamped visa approval. That actually seems to be relatively high stakes. Like, these visas matter to people. We're trying to reunite with family matters and so on and so, or family members. And they're important decisions. They're not, but because of the way that the weighting of value and risk and all of these other things happens inside government, I think certain perspectives get, they get more airtime, and then other perspectives aren't even in the room because there's no way for these folks to have a say in the answers to the question on the AIA. So I think that that's a real issue with the design of the algorithmic impact assessment. And I think there needs to be some rethinking about how different perspectives can be brought in to influence the use of this tool, in addition to ensuring that the tool actually gets used in the first place. I'll leave it there.
Yeah, no, as you noted, I think I agree with you that maybe one of the biggest pitfalls of the directive is there is no teeth. It's more like, it's well written, there is like good ideas, good principle, but if a department doesn't respect it, there is no much that one can do. There is no right of action for citizens. And departments spend so much time trying to argue to make sure that the directive doesn't apply to the systems. Sometimes just like, oh no, with just like an information on the side, well, it should be covered if you read the directive. So that, yeah, there's a lot of work to be done within JC. And what about in your region, Marcelo? Is there like any guidelines, act, directive on the use and deployment of AI within government?
Yes, so we discussed in the first panel yesterday a bit of the emerging legal landscape in Hong Kong and in the mainland. So there are interim measures that apply to generative AI and to the use of generative AI. Those are measures that are intended primarily, of course, to the private sector. But there is also an expectation that they will be applied by the government. So both in relation to generative AI, to the use of generative AI, and to development of generative AI, and we saw also the specifications that have been issued by the TC 260, the GB standard, a very specific standard detailing every process, every part of the process of development of an AI systems, and including provisions concerning retraining, provisions concerning labeling, and how detailed that is. And that is very, very interesting. And whereas for China, of course, there is the expectation that that will apply to the government and that the government will abide by it. There is what is the general challenge in the application of laws in a Chinese context to the government, in the sense that is a different, very different legal system from the kind of legal system we are used to. It's not to say that there is no mechanisms of judicial review, those are in place. There are petition rights. So the legal system in China has developing since, more strongly since the Constitution of 1982. And it's something that took a while to happen. But today we have a much more professionalized justice system. There are efforts in place to rein in corruption, to address corruption problems. And it's in many ways a legal system that is developing very, very fast. And in comparison with Hong Kong, for instance, in terms of how private matters are decided by the court, it's faster in China now than in Hong Kong. The challenge that we have when we come to China is issues of a public dimension, where public values are entailed, and where then the government is going to make those, the courts are going to make those decisions in ways that are different from the ways the ways Western courts would make those decisions. The idea of rule of law in China is a very different one. As I mentioned yesterday, the rule of law is one of the values within a system of socialist core values, which means that the courts need to consider, and they are asked to consider by the Supreme People's Court, the other core values as well. Party ideology plays a role in how courts decide legal issues. And party ideology plays a strong role in questions of public significance. To us, this, right, to a Western audience, this is something that may seem unthinkable, that the court would engage with this broader evaluative universe. But to me, it's a fascinating question because it raises the issue of whether our courts don't do the same, right? Whether they are also not engaging with values, just swiping things under the carpet. And at the end of the day, whereas the difference is not that these things are being openly articulated, and then there is an endeavor to articulate them in a coherent way, which we don't endeavor to do here. Right? So this is something that I think it's very interesting to reflect upon, and this is a very clear nuance of the legal system, and this is something that will play a role on how these issues concerning AI are going to be decided by courts as well. There are in China internet courts that conduct things entirely through electronic means of adjudication. Of course, at the end of the day, it's for the judge to make the call, but the drafting of everything, the submission, right, of materials from both sides, and the drafting of the decision, it's all done by through technology, and AI presents a final result then for the judge to, like for a doctor, right, to decide whether someone has a melanoma or not. The doctor will rely on the verdict of the AI. Will increasingly have the same in relation to internet courts. In Hong Kong, there is guidance on AI by the Office of the General Chief Information Officer, which is very interesting, detailing how the government should be deploying AI, very robust principles. It's a very well-conceived document that is to be applied to the administration as a whole. And like the standard in the mainland, but in a much more detailed way, it covers all steps of the process, and that is articulated, as I said, in a very interesting way, with a particular concern for transparency. But I think the greatest challenge that we perhaps have in relation to all that, in China more than in Hong Kong, but in Hong Kong as well and everywhere, right, is the interplay between the private and the public. The way increasingly administrative agencies need to rely on private actors for the development of technology, and how that makes the problem of transparency a very difficult one to tackle. How you can separate right? What is in the private domain from what is in the public domain, and it's a very difficult equation to close. In China, it's particularly more complex, because in China you have the public sector and the private sector very clearly intertwined. You have special kinds of shares of media companies, for instance, of technological companies, where the government sits, right, as a shareholder in boards and plays a very concrete role in the decision-making of private enterprises. And data is shared. Right? Data is shared between the government and private actors, and there is this corpus of data that develops there, which is understood as part of a broader idea of sovereignty, a new Leviathan, so to say, right? Where everything is there together, and I think this is a challenge from a Chinese perspective, but I think it's a challenge everywhere, right?
Yeah. So you were mentioning like the use of generative AI within government and so within the justice system. I think we will leave the question of the justice system to the next session later this afternoon. But maybe I would like to hear like Jen and Catherine on, like in your jurisdiction, how do you see the impact maybe of the arrival of like LLMs, within the public sector? Do you think that the tools that are like in place are like good enough to govern the deployment of such a system, or do we need to like maybe import new standards? So yeah, if you could reply to this question quickly, and then we will go to the room. If people have questions, please line up at the mic. Otherwise, I will ask many other questions that I have for our panelists. Jen, maybe?
Yeah, sure. I'll try to be pretty brief. So when I think about generative AI and how it might influence an administration, I always think about like the openings that might be the kind of easiest spots for it to slip in. Excuse me. One of the places where I could see it probably already working its way in would be through the creation of decisions or the creation of reasons. And when I consider generative AI's potential impact in that space, I always think about it in relation to what's already happening there. So in a lot of settings, there are already tools that are used to create skeletons of decisions. Depending on who you talk to, there might be more or less admission of the use of these tools, but in social assistance, for example, in Ontario, when I was doing my doctoral research, there is software that was introduced that through the kind of gleaning of information entered by caseworkers, and today probably by caseworkers and also benefit applicants or recipients themselves, the software would not just generate a payment or a decision about whether somebody was eligible or not for certain types of benefits, but it also created a draft letter that caseworkers were supposed to go in and amend, add different details, maybe finesse the language a little bit. But that was happening in 2014. In other contexts, there's templates of letters and decisions. Anyone working in immigration will be familiar with letters people receive that have like paragraphs that may not apply to the person or might have a list of things with one checked off. And somebody who receives that letter is supposed to make sense of it. And those are very likely auto-generated by software systems. Maybe somebody glances at them, maybe they don't, for intelligibility. But in addition, it's useful to think too about how very often we've had officials kind of collaborating with each other, creating decisions, or having like a junior official create a decision and then a senior official sign off. And I think that situation raises similar concerns about kind of authorship, who's responsible, who's making the decision. If the policy analyst or junior person is looking at a checklist that is intended to guide their discretion, but they use it as like a, somebody must meet these criteria, and if not, then they can't be granted the thing they're asking for rather. Like that type of collaboration and also kind of tension between all of those elements that craft a decision, you might ask, how does adding large language model generated text into that as another layer of decision maker change things or not? I think the questions about authorship have already existed. I think in administrative law, there's a lack of deep thinking about whose decision is it. It's the institutions. Usually the decision is made in the name of a minister or an administrator or a director. And there's this kind of parsing out of decision-making tasks that has already been happening for a long time, but we always kind of create this fictional individual administrator who rationally came to a decision as like the person who then we hold responsible, or that we want to retrain so they make a better decision. And then when we think of large language models, we think of them somehow corrupting this rational human being. Well, that's not what's happening already, and it hasn't been what's been happening in administration. So I think that to deal with large language models, we need to better think about what is it that administrative decision making does? Why do reasons for decision matter? If reasons are supposed to justify a decision and justify a conclusion drawing on law, then how might a large language model introduced into that space actually complicate or corrupt that, especially as we know large language models can do what's called hallucinating, creating laws that don't exist or case law that doesn't exist and so on. But also, what does it do to kind of unsettle or further unsettle assumptions that we already have that are not correct about, you know, who or what's making a decision in the first place in administration. So,
Catherine, do you want to?
Yeah, but I'd love to hear questions. So maybe I'll say something very, very brief, which is just, I think it's important in thinking about the kind of regulatory framework for us first to wrap our minds around machine learning, AI, and then ask the question, is there anything different about generative AI? Because many people jump to the latter. And so within internal governmental uses, my guess would be at the moment, you know, using sort of generative AI in a query way might be kind of like public-facing type things of giving information, but wouldn't really be, and we didn't find within government that those were the uses at the moment. The one other just sort of point I'd make is that I do think that there are like different roads to travel too. So the FDA really, in my field research within that organization, made this very distinct to me. You could do one of two things, right? The FDA has a pre-existing adverse event kind of database that basically has PDFs of like, you know, unorganized, unstructured text. So you could look at that and you could use natural language processing, and then you could use LLM models. Or you could say, should we think about how we're going to have fit for purpose data and go down a different route and think about how we might get directly the health and safety data that we might need with privacy concerns, et cetera. So there is this sense in which, you know, I think government's pretty good about thinking about like do we have a problem, and then we're going to solve it, as opposed to, I do think we too have people in government showing up saying, we've got the latest, greatest tool, it will save government, but they're not so interested in that at the moment.
Okay, thank you. So I see that we have one person line up, so Cristiano. Very short, please. Oh.
All right, sorry.
Wait.
So I cannot resist to ask this. Much of the public discourse about regulating AI is about the ghost of China, you see? Because we cannot over-regulate, but because we cannot be in the way of innovation, otherwise China will conquer the world, right? So let's stay in the minimum of legislation, whatever it is. Let's complain about Bill 25 in Quebec, because also it gets in the way. But at the same time, from what we're hearing from you, Marcelo, and what we see in the news is that China is having a lot of legislation, detailed legislation about AI in many instances, different instances, including privacy, cybersecurity. And I want to, and at that same time that we have here in Canada and the US, not much to show and tell, you see. We can discuss interpretations, go beyond, but We don't really have a legislation for that. So it's my quick question. Do they say anything there over there? We need to regulate this, otherwise we become like Canada and the United States, or no? You see, and about this too, do you think really any legislation, regulation, I know there's discussion of democracy, gets in the way of innovation?
No, that's a very good, is this working?
Yeah.
No, that's a very good question. And yesterday and today, when I'm talking about China and making a contrast, I often say our way of doing things, right? I put myself outside. What I'm trying to do, right? And I think I have a special duty of doing that because I'm in a place which is a place of so great openness and diversity, right? Which is Canada, and which I admire immensely for it. I think I have a special duty of trying to present things in as balanced a way as possible. Of course, there are negative things, right, in China. There are things that I don't like. And you'd be surprised to know that I think I can speak freely about these things in Hong Kong. I don't know colleagues who have been asked not to publish something or not to write something. Of course, it changed much after the national security law and everything. But going back to the question, I don't see China as framing itself in its development, which is already so complex on its own, trying to frame itself in adversity with the West. I don't see it as a guiding principle. Actually, I think it's the opposite. There is an endeavor of integration, and this is written in the interim measures, for instance, on generative AI, the recognition of an interconnectedness, and that there is a need for cooperation. Of course, it's difficult for the West as well, seeing that the multilateral framework has led to the strengthening of China and the emergence of perhaps a new paradigm. But I think the real question is whether that paradigm is so different that we cannot make an effort, right, to come together and to appreciate the things that we share in common and how we can best make a decision which is in everyone's interest.
One last question, and please just one question and one sentence. Thank you.
One question, okay. Thank you to everybody who spoke today. My question, I think, is directed for Catherine. I'm interested in decision support platforms and applications, particularly those that are enabled by technology to make policy decisions, so certainly in line with some of your research. And I'm curious to know more about the 50% of cases you found that created their own sort of internal tools and the ways in which they went about testing the veracity or accuracy of those tools themselves. You mentioned briefly, at least a passing comment about automation bias, and there are a series of challenges, obviously, we have between human and sort of machine interaction, or at least within that space. So I'm just curious to know more about your findings in that area and maybe what concerns you about what you found.
Just maybe I'll clarify one thing. In this government by algorithm, and you're welcome to go read the report. It's actually readable. I mean, we made it be readable. We did a first part, that's the canvassing of all 142, and for that, we only relied on publicly facing documents. I don't think I clarified when I said we're sort of like a microcosm, but there's some missing elements. The way we did it, and I think it was very fruitful, was have the technologists and these were students, but we also had social scientists, lawyers, law professors, to have us in the same room reading the same publicly facing documents. It was phenomenally productive because the lawyers read things a certain way, the technologists, who seem befuddled otherwise by like, what is this principle? So that was very, very edifying. In that process, we then had the computer scientists try to do things like rate the sophistication of the tool, and in the vast majority, there's not enough information to do so, and there would be no way really to test what you just said of sort of like how accurate, et cetera, are these tools? We actually tried doing a survey that was just not helpful at all. Actually, we have an executive order that has asked federal agencies to put up all of their internal use cases, and I will humbly say that you'll get more information from the ACUS report than from any of the self-reports. I mean, they're not very complete from our federal agencies. The way we tried to get at your question is we then, in part 2, did a deep dive into a few select agencies. So the SEC, the FDA, and we learned quite a lot about the tools that they were using and how much effort they were putting into testing them, to piloting. It was over and over said, everyone is very interested, not just in the speak, but the actuality of how do you fail cheaply. So when you're the FDA, you don't fail cheaply by having like a massive public experimentation, but they have really sophisticated, they had these, real world data kind of experiments that they had been running, and then they tried it in a new context and it completely failed. And it's a very iterative, very serious, sophisticated process. I think it would be, in the best of circumstances, again, I'm not Pollyanna, it's just where I sit, I have people saying we should ban this technology, and others like it's the go innovation, we never need to regulate. And I think that we saw some good examples of these tools that were being developed internally with this idea of those developing the tools were thinking with the people who are enforcing the tools, with the rule designers, et cetera, in the same place. So, yeah, I have a lot of worries, because here's my biggest worry, right? There were great partnerships, like the FDA has entrepreneurs in residence, et cetera, but the phenomenal kind of like talent that you need to be doing this can go elsewhere and get really heavily compensated, et cetera. So there are mechanisms, there's partnerships, there's this. I'm not going to say they aren't, but I guess my biggest worry is I am a big believer in the internal capacity building of federal agencies so that they can have mission-driven tools, context-specific tools, and you need a lot of embedded expertise and internal, not just for a few years. Some of the people, I'll just say that, I interviewed back then, they're no longer in the agencies now, and that's the thing that makes me less optimistic about how this is going to all play out.
Perfect.
Thank you.
Thank you so much. Please join me thanking our panelists.